Hi everyone, I'm back with another video. It's been a while. It's nice to be back in front of you to provide some information. Today I want to talk about prosecutorial discretion. It is a new way of doing things in immigration court. It's not completely new because it existed before. I think it's very important if you have an immigration court case pending that you should watch this video, or you know someone who has an immigration court case pending. You should definitely recommend them to watch this video. I want to provide some very critical information. Before we start, if you think that you are benefiting from these videos, hit that subscribe button and give us an opportunity to reach more people. So what is prosecutorial discretion? Prosecutorial discretion is basically the opportunity provided to the government attorneys to close a case, terminate a case, or stipulate to any type of relief. What do we mean by this? Let's take a little bit, move back and explain what is the immigration court. Very briefly, immigration court is basically removal proceedings or deportation proceedings, technically, different types of proceedings. Government has to successfully, legally argue and get it approved by an immigration judge for somebody's removal from this country. Because of that, there's a court system here, not necessarily technically like regular courts, but a tribunal very much similar to courts that has to follow due process. We have the government attorneys on one side, and we have you, the respondent, on another side. And the government attorneys are arguing for your removal from this country based on specific reasons stipulated in the prescribed in the immigration laws. On the other hand, you're arguing that you shouldn't be removed from this country because you're entitled to asylum, or you're entitled to cancellation of removal, or somebody, an immediate family member, is sponsoring you, let's say. So what was happening before with the Trump administration is the Trump administration was instructing the government attorneys to argue for the removal of anyone and everyone that can be removed, basically. There's no other way to put this. And because of that, we were seeing a lot of unnecessary trials, like we were going to individual hearings, and even with very strong cases, and they were being, litigated to the end, that, for the removal. Let's say there is an approval from the judge, a relief grant, and then even in that case, the government attorneys were instructed to deny and appeal those decisions. So what changed? What changed is now they have the discretion to decide if they want to litigate or not. And this is necessary because we're talking about more than 1 million cases pending at the immigration courts, 1,300,000, I believe. And it doesn't make sense to try and litigate all these cases. The government doesn't have enough attorneys to handle this type of caseload. It's not possible. It was hard to imagine a policy that will be feasible the way the previous administration did, that to litigate all these cases, litigate the removal of all these individuals, more than 1 million. But now we have something different. Now we're seeing that there's a way to reach out, approach the government attorneys and ask them to terminate certain cases. Let's say you have an I-130 approval pending. Your wife, your father, or your child, your parent or your child, immediate family member, sponsored you, and you're an approved I-130. And in that case, there's no reason for the government to argue for that individual's removal. So we are asking them to agree to a joint motion to terminate proceedings. That way, the individual can get their green cards, the I-485 application, through USCIS, unlike going through courts. Or another method is stipulation, which I think will be very important for those with strong cases. Is we prepare the application for relief, which is usually a statement corroborated by supporting documents, and then we have a legal brief arguing why the individual respondent is entitled to this type of immigration relief. We were preparing these packages anyway in the Trump era, and we were arguing them at trials, basically individual hearings, and we were fighting tooth and nails to get a grant for immigration judges. Now it will be possible to ask for a stipulation before the individual. Let's say you don't have an individual hearing date yet, which could be years from now, thanks to a crazy amount of cases in the backlog, more than 1 million. Now we prepare the same package. We put together a decent, very good statement. We corroborate that with supporting documents. We put together a legal brief, very strong, and then we send it over to ICE, to be exact, government attorneys or Office of Principal Legal Advisors, and we ask them, here's this application, here are the facts, here is our legal position. We think this is very strong. Don't waste your time and agree to this. Let's do a stipulation, and let's not waste your time on our time. Let's do a settlement, if we may. This way, we will be able to get relatively faster relief for those with strong application, instead of waiting for a couple of years for an individual hearing date to be set, which could be a very long time. Now we are in a position to ask the government to, hey, there's this case, this is our argument, let's come into a settlement and get the relief that the respondent needs. So they want to do that because they want to decrease the amount of cases they have pending. And if you think that you have a strong case pending with the immigration court, don't hesitate to reach out to discuss. We'll be more than happy to see what we can do. Or you think that someone who has a case which is very strong, waiting for years, and looks like they will be waiting for years, let them know. They can reach out to us or another experienced immigration attorney to discuss the possibility of doing something like this. Thank you for watching, and be safe. Thank you.